Hello and welcome to The Big Picture. In a landmark judgment which can have long-term implications on the way the natural resources are allocated in the country, the Supreme Court has found all coal block allocations made from 1993 are illegal. The judgment means that entire allocations made by various governments since 1993 through the screening committee and dispensation routes were arbitrary, casual and illegal, as the apex court said. However, the court has said that as far as the 218 coal blocks under contention is concerned, the court has said that it would require further hearing to decide the consequences of the illegality of the coal blocks. What does this judgment mean and what are its implications? We will discuss that today with Prashant Bhushan, advocate in the Supreme Court who was also one of the petitioners, Ajay, former Secretary Industries and Commerce and also had stint in the Power Ministry, Parajanjoy, Guha, Thakurta, senior journalist and economic analyst. Welcome to all of you. Prashant, is this, would you consider this as a landmark judgment?
Yes, it is a landmark judgment in several respects. Firstly, it says that these allocations of coal blocks had to be done by the state governments.
Right.
And they could not be done by the central government, and the central government has illegally usurped that power. Secondly, it says that these allocations could not have been made to state public sector corporations or to even private corporations who did not have already established end-use industries where they could use this coal.
Right.
Thirdly, it says that all these allocations made by the screening committee or by the government directly without the screening committee have been done in an arbitrary manner, without first laying down a criteria for allotment, without examining the inter se merits of the various applicants, without even verifying the claims put forward by the various applicants, etc. Right. In a wholly arbitrary, nepotistic and sometimes corrupt manner, these allocations have been made right from 1993 onwards. There was no system, there was no transparency, there was no rational decision-making process for deciding comparative merits, etc. And therefore they have declared all these allocations as illegal, which means that all these allocations stand quashed, and all that the court now is going to decide is what happens to those people who are mining there already.
Right.
Of course, their mining leases ipso facto also become illegal. Now the question would be, what would happen to the mined material which is lying there, etc. What needs to be done to all those things? These are the issues that the court would decide when it hears the matter further on the 1st of September.
Okay. Okay, Prashant, I'll come back to you. That I mean, you've given us a clear idea of what the judgment is. Mr. Ajay, I mean, isn't it incredible that all these years, Government of India has not been able to come out and have a policy on this, and now the court says that all that has been done since 1993 is illegal. Central government had no powers to do it. State government should have done it.
I think what's just been described as the contours of the judgment which were just talked about, it's certainly a very important, significant judgment which is a reflection on the governance all these years. But I think a couple of things we need to separate from what has been. One, the screening committee was all along a recommendatory body. The powers of allotment have been exercised by the Government of India on the recommendations or sometimes without the recommendation, as we saw a particular case in which Mr. Parekh and Mr. Birla were involved. The screening committee had probably said something else because the powers vested in the government. What has been commented upon adversely is that the government did not lay down any criteria or did not lay down guidelines for the screening committee to make its recommendations. In as far as the state governments are concerned, I think that comment which the court has made and which was just now highlighted, that making an exception in the case of state mining corporations or state corporations which did not have an end use also amounted to violating its own guidelines which it had framed. And we must recall that in 2003, the Coal Nationalization Act had said only the government can market, government can mine and government can market. Thereafter, a couple of amendments were made which allowed allocation for captive mining.
Absolutely.
As long as it was being used for your own purposes. But to go ahead and give it to state mining corporations, make an exception, and they in turn went about forming joint ventures for particular mines allotted to them, gave them either the right of the full allocation or partial, etc., that has been certainly misused, and the court has come down heavily. As far as the state governments are concerned, I think that issue has not been so openly commented upon, because coal is a major mineral. Major minerals vest in the federal government. In the union government, minor mineral allocation is there. But even here, the lease deeds have been, or leases have been sanctioned, concessions have been given by the state governments on the recommendations or on the allocations done by the federal government, which alone had the powers to deal with it.
Prashant, can you clarify on that, about the state governments? Why this thing came up? If it was the powers of the state government, how come all these years none of the state governments have exercised those powers or claimed that or told the center that you can't do it, we have to do it?
Yeah, this was proceeding on a complete misunderstanding of the law, because the law as analyzed by the Supreme Court under the Mines and Minerals Development and Regulation Act, the power of allocation even for major minerals is still with the state government. The only thing is that it has to be with the prior approval of the central government. But the power of selecting the allottee still vests with the state government. In this case, in the case of all these coal mining leases, the central government had usurped that power by making the allocations, and the state governments also felt that the power of allocation was really with the central government, and therefore they had abdicated their responsibility in favor of the central government.
Prashant,
they were saying that thereafter they were just following a mechanical procedure of seeing whether these allottees had received the various clearances under the Environment Protection Act, Forest Act, etc., and thereafter executing the leases in their favor. So therefore, by virtue of these allocations having been declared illegal, the mining leases given consequent to these allocations would also ipso facto become illegal.
No, Prashant, I'm just reading from para 155 of the judgment. Here it says the allocation of coal blocks through government dispensation route, however laudable the object may be, also is illegal since it's impermissible as per the scheme of the CMN Act. No state Coal Mines Nationalization Act.
That's right.
No state government or public undertakings of the state governments are eligible for mining coal for commercial use.
Absolutely.
What does it mean? What you are saying and what I'm reading from here seems to be contradictory.
This is where, can I just...
1 second, let him
Yes.
I'll come to you.
No. You see, you are confusing between two different things. I was talking about the general power of granting mining allocations or mining leases, etc. The court has said that power vests with the state government. Right. However, under the Coal Mines Nationalization Act, originally coal mining was permitted only by the central government and central government corporations. Thereafter, that was amended to provide that even other companies who had end-use plants of steel or power or thereafter cement, those were also permitted to get coal mines for their captive use. But what the central government or the government dispensation route did in this case was that they granted mining leases to state government PSUs, for commercial mining. That means they did not have end-use plants of steel, cement or power, and yet they were granted for commercial mining. That was not permitted. Only central government or central government PSUs were permitted commercial mining under the Coal Mine Nationalization Act.
Yes, Mr. Dua.
The powers for major minerals as well as under the CMNA for coal, to my mind, and I'm not a lawyer, eminent lawyer like Mr. Bhushan, vested in the central government. The central government exercised the powers on recommendations of a screening committee which had no legal basis. But as an ad hoc arrangement continuing from 1993, the composition of it also the central government decided, etc. And the option was before it to accept the recommendations or not. But it complied with the MMDR Act by actually executing the leases between the state governments and the allottee.
The private.
So the compliance was being done. So here was a way found out that the allocation is done by the federal government, but exercise of the leases is done by the state government's grant of concessions. And if you recall, number of cases we have seen recommendations of the state governments were received for each mine, and those were put up before the screening committees.
There is a lot of... Yes. In fact, the judgment discusses each case which has come up.
So this was a way which had evolved over the years, that the state governments are involved, their suggestions are invited, their recommendations considered, and finally the allotment under the MMDR Act is also done there. But being a major mineral and the CMNA Act requirements, the entire power was being exercised by the central government.
And which according to what Prashant is saying and what the judgment, that they were exercising wrongly.
I'm not quite sure. I think if it's come out that clearly. Yeah.
Girish,
Parajanjoy,
let's try and look at the big picture.
The judgment.
One second. Yes, Prashant.
I was saying that the judgment very, very clearly says that this understanding of both the central government and the state governments, that the power of allocation really was vested with and being exercised by the central government, and only the lease was being executed by the state government, that this was an incorrect understanding of the law. In the law, the power of selecting the allottees still remained with the state government, notwithstanding the fact that coal was a major mineral for which prior permission of the central government was required.
Which act are you talking about?
Prior permission,
no, Mr.
you could not...
No, Prashant, which act are you talking about?
The MMDR Act.
Sorry?
MMDR Act.
MMDR Act. Okay.
The Mines and Minerals Regulation and Development Act.
Right.
In that act, the power of selecting the allottees is still with the state government, though prior permission of the central government is required.
Okay. Yes.
But in the guise of this prior permission, you cannot take over the power of deciding the allottee, which is what the central government had done.
Okay.
Let's look at the big picture. What the Supreme Court has said is coal is a very, very important mineral. In fact, the entire economy, it's an extremely important mineral, because more than half your total energy that you are consuming in this country is based on coal. That's point one. And therefore, this judgment is not only a landmark judgment because of its implications in the manner in which natural resources are allotted. This judgment is significant because it's going to have an impact on the entire economy of the country. Point one.
And also on all the other natural resources.
What has been said that besides electricity, there's steel, there's cement, And if you look at it, in 2013-14, India produced roughly 550 million tons, of which about 500 was used for what they say thermal coal, used for thermal power generation, and about 50 was metallurgical coal. And of that amount, it's only about 10% which was captive of that thermal coal. But what is very important is, please understand what the Supreme Court has been categorical. It said that the manner in which these allotments were made, 218 of these from 1993, when Mr. Narasimha Rao was the Prime Minister of this country, to all the way through 2010. So in between we had Mr. Deve Gowda as the Prime Minister, Mr. Gujral, Mr. Vajpayee.
The entire spectrum.
That's correct. NDA, UPA, everything. And in this period of time, you allotted these, the allocation was done according to the Supreme Court in an illegal and unconstitutional manner on the following grounds. 1. Non-compliance of the mandatory legal procedures under Mines and Mineral Development and Regulation Act. 2. Breach of the Coal Mines Nationalization Act. 3. Violation of the principle of trusteeship of natural resources by gifting away precious resources as large as that. We were actually gifting away natural resources for nothing to these private companies. 4. There was arbitrariness, lack of transparency, lack of objectivity, non-application of mine. And finally, 5, this allotment was tainted with malafide corruption in favor of ineligible companies, etc., for which there are various CBI inquiries, etc., that's going on. Look at the number. The total was 218, but actually a number of them were already, ineligible. So there were effectively 194 that happened. 194. Right?
There's deallocations.
These are the ones that you're talking about, which have begun production. How many are left? There are only 30 of them. Roughly 30 of them. The issue is that the Supreme Court has held that all allocations made by the central government are illegal. But the allocation, that means no allocation letter will have a legal effect. I mean, that is essentially the way one is interpreting it. Now, the only question that the court has left open is that in those few cases, and this is 30 cases, where state governments have signed mining leases, and there's actually mining going on, and people are engaged, and as Prashant was saying, minerals are there. What happens? And that is going to be decided on the 1st of September. The point is very simple. The allocation letter issued by the central government does not give by itself a right to mine, but it gave a very, very valuable right to an applicant to exclusively apply for a mining lease with the state government. And only when the mining lease is signed can you actually mine. So this is the point. And the second point you must note, that the bulk, the mean allotments, and these are the most important allotments, were made during Dr. Manmohan Singh's time.
That is the point.
And
that is exactly the point.
And many of these allotments, I don't remember exactly when. Yes, 155 of the 218 blocks were allotted when he was Prime Minister. And a bulk of these 155 were allotted when he was holding charge as Minister for Coal. Now the point is, one last point I want to make. You see, you have to realize that what happened actually. There were a whole bunch of people, gutka makers, CD makers, newspaper barons, who all got these coal mines.
In these last
That's correct.
few years.
When the Controller and Auditor General of India brought out its report, and the first initial calculation was 10 lakh crores. Finally, the report that was presented in Parliament said 1,86,000 crores. Now, at that point of time, you must remember that the then Prime Minister, Dr. Manmohan Singh, gave a personal statement, which is a very unusual circle, in the Parliament, justifying all the actions that he had been saying. Now, this Supreme Court judgment has clearly upheld the contention of the CAG, which was Mr. Vinod Rai, and in a sense has, not in so many words, but not accepted the arguments that were put forward by the then Prime Minister, Dr. Manmohan Singh.
Yes, Ajay, before I go to Prashant.
I think this was something which was coming. We had seen the way the Supreme Court acted in the 2G allocations.
Right.
This was, I would say, widely apprehended that such cancellation of allocations would take place. The question is now the court has to decide what happens to the 160 or 165 mines where no action has taken place, mining hasn't commenced.
Yes.
Whatever reason,
114 of them,
whatever the reason might be, whether it was environment clearances were not given, regulatory clearances, there are disputes between the parties who have been jointly allotted it, or the parties didn't have the caliber, the competence to mine, etc. Because these are some of the reasons. I think cancelling those mines is an easy job and should be done. But the limited issue is the 50 million tons, and which is also just about 1/10, as he was pointing out. Those 30-odd mines, how do we continue mining there, or do we stop it?
And what would be the implication?
My concern, and let me just, is that today we might be the second or the third largest coal reserve holder in the country. But we have become, in the world, sorry, and we have become the second largest importer of coal in the world.
That's right.
145 million tons we imported last year.
Right.
So are we going to further, if we stop this production of these 50 million tons, I don't know how much is actually happening, whether it's 30 or 55 or so, that's going to adversely impact the economy. It's adversely going to impact power. Whether a way can be found out by the court that otherwise the effects on our current account deficit, international price of coal will shoot up the moment in view of the judgment. So those kind of things will be the next action to happen.
Just 2 points I want to make in response to what Mr. Dua said. We don't know yet what will happen to domestic prices. It may not happen. In the recent past, international prices have been somewhat stable, I should say, they haven't shot up. I mean, and right now, it's not much of a difference between the Indian prices and domestic. But as he rightly pointed out, despite the fact that we have one of the largest reserves of coal, we are importing between a fifth and a fourth of our total requirements. I mean, there's something terribly wrong. One minute, one more point. And this is that you are today in a situation, and this you must remember, that when Dr. Manmohan Singh became Prime Minister in 2004, he personally put on record that this should be publicly auctioned. At a meeting in October 2000, and it was put out that this should be allocated on the basis of competitive bidding.
It took 8 years for the government.
It took 8 years, that's correct.
It took 8 years for the government to come out with a policy.
In this period of 8 years, the best blocks were sought to be allotted to cronies of the government.
Prashant, this is one of the major things, this is one of the things which the Supreme Court notes in its judgment also. Now what? Now what next? As we have all been discussing here, it's actually a question of 30, 35 blocks which are functioning. So the whole question will revolve around that. But what about the larger political implications of this judgment?
See, firstly, those blocks which are functioning, if they are with the central government or central PSUs, they will continue to function because those have not been cancelled, those allocations. But those which are with the private people or with joint ventures of state government PSUs and private people, etc., only those have been cancelled. And there, I don't think that they can be allowed to continue mining in those leases which are consequent to illegal allocations, because the leases would have to be declared illegal because they are consequent upon these illegal allocations. So therefore, they cannot be allowed to continue mining. The issue
even the public sector
those particular leases would have to be now
even the central government allotments or central government companies, even their allotment to them is also illegal.
Absolutely.
So there can be no distinction. There can be no distinction between
central
NTPCs.
government allocations may not be.
No.
Why would it not
central
be illegal?
Government PSU allocations may not be illegal. I don't think.
This is only
I
Coal
don't
India.
think those would be
only
illegal.
Coal India.
So far as allocations to central
NTPC,
PSU.
Yes,
DVC,
yes,
one second.
all of them.
Yeah, please continue, Prashant.
Yes, as well as state PSUs which have end-use plants, etc. Perhaps I'm not sure about those either, but so far as the others are concerned, those would certainly be illegal. Those need to be now quickly put out to auction, and that should settle the matter, because there should be no impediment. In fact, one of the problems...
Prashant, sorry, yes. My question is this. Now that, the Supreme Court has declared everything which has been done since 1993 as illegal, now how do we go about it? Now, is it the new government's task now to come out with some kind of a policy how to allocate, or should they go back to what the UPA government had actually by 2012 come out with this saying that, all these things needs to go through the bidding route?
It has to go through the bidding route, because already there is an amendment which has been made in the coal mines, in this MMDR Act.
Right.
11A has been introduced, which obliges auction of all future leases.
Right.
So therefore, you will have to auction it in any case. In fact, one of the reasons why many of these mining leases could not get operationalized was also because of the totally arbitrary, illegal manner in which they had been allotted.
So is there...
If you allot to ineligible companies...
My question, Prashant, is, do we imply from this judgment that the Supreme Court has willy-nilly upheld the auction process, and that is what the government will have to follow now?
No.
No, that is there in the Act itself.
The Act itself has been amended.
Act itself has been, okay, right.
I think let's...
so far as the...
Okay, Prashant, yes.
The screening committee since 1993 has been allotting all the blocks, including to NTPC, state government undertakings, DVC and others. If the screening committees did not have the powers to do so, as has been pointed out, I think the government will have to revisit all the allocations.
All the allocations which have been done.
Whether it was to a Government of India company or a state government company, that's point number one.
Yes.
A number of these mines are functioning, particularly the ones with the public sector undertakings.
Right.
So my concern is that unless a way out is found out very quickly, you could see power disruption.
Right.
Already some of these companies, and we keep reading from day to day, have critical stocks, 7 days or below stocks,
4 days, 3 days.
So a way out has to be found if all the processes of screening committee or all the recommendations have been found fault with, which is the case. Second, the Supreme Court has not said which way to go about for future. I think we may have to handle this issue legislatively. Okay. Now, how do we keep the economy going till the process of...
Legislatively means they are saying that already the Act has been amended.
I'm making a point.
Okay.
It is the MMDR Act, the section which has been amended, talks of future leases.
Right. So it doesn't talk of what...
I am talking of you have to keep the system going.
Right.
And second, I think the government should keep away now from allocation, exercising the powers itself, because there are discretion with the government, means crony capitalism, favoritism. It must be given to an independent regulator, coal regulator, who is so far not been vested with these powers.
Right.
Only talk, nothing has been actually done.
You need to empower that person, and the fresh leases, please give them on the way you have done it for ultra mega power projects,
UMPP,
which is that all the clearances, whether they are federal clearances or provincial clearances, are first obtained, and then the blocks are put for auction. And earlier it was tariff basis.
And Duaji, most importantly, the coal that you are going to that you are mining will be used for captive purposes. So you can't sell it.
It can't be for commercial use.
That is not allowed under the Act itself.
We're running out of time. Parajanjoy, last words to you. What will be the political implications of the judgment? Very quickly.
It'll be huge. I think, see, as what I was saying, I think these blocks will have to be re-auctioned, the allotments. I think you name the corporates, they're all involved. Jindal, Birla, Tata, Reliance Power, SKS, you name it, GVK, Lanco, I could go on and on.
Yes.
Who are the people associated with them? Who are the ministers involved? Santosh Bagrodia, Dasari Narayan Rao, Sri Prakash Jaiswal, Abhijit Group, Vijay Darda, these are important political figures whose names willy-nilly figure in the Colgate scam. And I think since the bulk of them were associated with the Congress party. It is the Congress party
Which is
in
going to
particular and Dr. Manmohan Singh in particular, who will actually have to, in a sense, have to bear, will the outcome, the fallout, the political fallout of this particular Supreme Court judgment will be on them. And, and the issue is really on how to ensure that the economy is disrupted the least.
It's not
disrupted the least.
Yes.
That this auction process is happen in this competitive bidding, public auction happens expeditiously.
Okay, I think on that note, we need to end. It has been a very fruitful discussion. Things have got clearer about what the implications of this judgment are. As we go on in the next days and weeks, it will get much clearer. But one of the important things, the political fallout of this judgment is something which we'll have to wait and watch. Thanks to all my guests, Prashant, Bhushan, Ajay Dua and Parajanjoy Thakurta. Please keep watching. We'll come back with another issue on The Big Picture, same time tomorrow.